So I would just talk very briefly about generative AI adoption among legal professionals, just having a brief discussion on the issue of hesitancy in terms of adopting uh, these tools. And of course, full disclosure, I'm definitely not as much of an expert as many others who have spoken before me, and probably those who will speak after me. But I'm just one who is keenly interested in the subject of how legal professionals, including myself, have reacted to generative AI in the legal profession, particularly since obviously ChatGPT was released and everyone thought that that would be the next best thing to have happened to all of humanity. But in the legal profession, I would just go straight to the next slide. For the most part, and many of the surveys that have been conducted on the adoption by legal professionals of generative AI tools, including ChatGPT and other bespoke LLM tools like Lexis Plus AI and Vincent AI. So what the surveys have shown so far is that the attitude towards the adoption has evolved, especially since ChatGPT was first released. Initially, um, quite a number of lawyers expected that the tools would be adopted by their law firm sometime in the near future. A significant number in Europe, North America, Canada, New Zealand, Australia reported experimenting with these tools. And so, but over time, what has happened is that a significant number of lawyers have kept on using it, for personal use, but to a limited extent for professional use. And many of these surveys are the surveys that were conducted by LexisNexis, Thomson Reuters, and some other legal tech providers. And they covered a different range of lawyers, but I don't want to focus on the results of those surveys because they are, first of all, publicly available. And that's not even the essential aim of what I just want to briefly discuss. So, like I said, the state of play is that there has been an influx of LLM tools supposedly tailored to the legal profession, including, like I said, Lexis Plus AI, Vincent AI. The initial reaction to all of these tools, as is customary of lawyers, the initial reactions were mixed. Some said, yes, let's go, let's adopt, let's go forward with this. And others are like, there are so many concerns we need to actually review. And then you also have some other people who are trying to find a balance in between. That's where, and I believe for the most part, that's where we still are now. Everyone is kind of getting to the point where it's like there are a lot of concerns, but we can't do something with these tools. Now the question is, what exactly can we do? And I was listening to the talk by uh I'm not sure it's Dr. or Professor Dayan earlier, who was talking about some of the limitations as well with these large language models, especially for legal work. So that's an example of trying to consider things from various aspects that most legal professionals are also trying to do. So that's, for the most part, the state of play. But there is still a cautious optimism that these tools would actually make positive contributions. Now, there are challenges that are associated with the adoption of these tools, particularly in the legal profession. One of them, like, has been discussed at some point earlier, ethical considerations. Most lawyers are cautious about accuracy of information provided by these tools in response to legal queries or in response to legal tasks that are required. And of course, we have quite a number of cases where lawyers have erroneously cited non-existent cases that have been relied upon in court documents, and some to a bit embarrassing outcomes. But people, that obviously just shows that there are some considerations that are still being discussed regarding the accuracy of the information provided by these tools, regarding confidentiality of information used, to prompt these tools to actually generate information or perform these tasks. Those are just the examples of the ethical considerations that lawyers take into account in their hesitancy regarding these tools. Another one is the generally conservative nature of the legal profession when it has to do with change and adopting, new techniques and adopting new forms of doing business. Law is a very conservative profession filled with many rules and standards and ethical practices that you need to take into account. And just sometimes generally lawyers are just not willing to actually take a big leap to doing something different until a long time has passed, and probably other professionals have moved on to something else, and then lawyers now decide, what, maybe it's a good idea for us to actually move into this. So there is that conservative nature of the legal profession that plays out as well with respect to these tools. And of course, there is the threat to the billable hour system of actually getting legal fees. The idea that if these tools actually work the way they're expected to work in terms of actually helping lawyers do work in far less time, clients will begin to actually question why exactly are the lawyers charging this way if the tools they are relying upon are able to help them do work, in much less time. And it's maybe seen as a bit of a threat to the billable hour. So those are the three main issues I just wanted to highlight as some of the challenges in relation to actually adopting this tools whole scale. Of course, there is the finance aspect as well, especially for small to mid-sized law firms, especially when it has to do with more bespoke tools, and whether law firms are actually willing to invest that much in these tools is one thing that they also have to consider among other business choices. The solutions, these are not necessarily strange solutions. I didn't invent them from my head. Many other legal professionals and experts and academics have probably talked about them as well. The need for lawyers to actually understand the limitations and the risks associated with these tools, the need to actually balance tradition with innovation, the recognizing nevertheless the potential of these tools to actually optimize workflows, because we cannot deny that if properly used and if effectively used, they have the capacity to actually enable lawyers perform various aspects of their legal task or augment their practice in ways that would actually benefit them, exponentially. So also considering the possibility of moving to an alternative system of actually charging clients or being remunerated for legal services, which actually moves more to the value being provided by lawyers as opposed to just working by the hour. So those are the solutions that I highlight as well. And this is where I now
1 minute.
Yeah, this is where I now share my own thoughts, in that there is a need to move beyond the misconceptions associated with these tools. One of them is the need to actually properly contextualize the role of these tools as assistants, not replacements. Also, we need to properly weigh custom-made and generic LLMs, put them in the right context, and also consider the fact that it is not just about the technology, it is also about the user. And just by way of conclusion, I just feel things to just think about regarding the future. what is going to be the impact of increasing use of these tools by judges, what is going to be the impact of studies that question the reliability of these tools, and like the previous presentation, what is the impact of these tools in relation to access to justice? So in a nutshell, that is essentially what my presentation is about. Thank you for the opportunity.